Is your trust a ticking time bomb? And what can you do about it? Mistake number one, having the wrong trust structure. Costly consequences of an AB versus a non-AB trust. This is for couples. A tale of fixing a trust. So Larry and Susan have a $3 million estate, including their home. Susan outlives Larry by 5 years. And by the time she passes away, when assets go to their kids, their estate grows to $5 million in value. Their children face over $300,000 in capital gains tax exposure. Wyatt and Jane, same situation, $3 million estate, including their home. Jane outlives Wyatt by 5 years, same thing. The estate also grows to $5 million, but because of a change they made to their trust structure, their children face zero capital gains tax exposure when their children inherit assets. So that's a difference of $300,000 in potential taxes just from changing their trust structure. Tale of fixing a trust, a larger estate. So Ben and Ann have a $10 million estate. By the time that they pass away, if the second spouse passes away, I should say, grown to $18 million. Their estate ends up facing over $1 million in estate tax. Jacob and Sarah, same situation, $10 million estate. Their estate also grows to $18 million by the time they pass away, but because they made some changes to their living trust structure, zero estate tax exposure. Now, before I uncover these mysteries, I'm going to take just a moment to introduce you or reintroduce you to a couple of really important concepts when we're talking about estate planning. One is the stepped up basis. So say you have a share of Google stock, you bought it $50 a share, now it's worth $100 a share. If you sell it, you have to report to the IRS, well, I paid 50, I sold it for 100, I made 50 bucks on that. That's your capital gain. Depending on how long you held it, you have to pay either short or long-term capital gains tax on that. It can be a punishing tax. It can be 30 or even 40% in some cases if it's a short-term tax. The key concept you have to understand, a lot of people are confused about this. Everything in your taxable estate when you pass away, my taxable, so anything that you own when you pass away gets a stepped up basis. This means that the IRS says, hey, if dad bought Google stock for 50 a share and now it's worth 100, if it was worth 100 when he passed away and then it goes to his kids, if they sell it for 100, they can report a gain of zero. They don't have to report what dad paid for it. They only have to report what it was worth when dad passed away. It's called a stepped up basis, meaning capital gains taxes are wiped away as long as it's in your taxable estate. Applies to stock, to real estate, to other investments. It's a pretty powerful thing. Now, take one more moment just to introduce you to another key concept, the estate tax. Now, just how many families, what percentage of American families do you think are currently affected by the estate tax? 0.1 to 0.2% of families in America are affected. So it's 1 in about 1,000 families, because the exemption, the amount you can pass tax-free, is currently, and I mean currently, that's a crucial point here, $12.92 million. It's at a historical high. However, so you, unless you have, if you're a married couple, you can pass almost $26 million free of estate tax. Now, if you're single, it's up to about $13 million, but we have to be aware of the fact that unless major changes happen before then, on January 1st, 2026, the exemption is going to be cut by 50%. So it's going to go down to about $6 or $7 million per person. Your estate's hopefully going to keep growing in the next few years. Let's hope the economy turns around right as the exemption drops. And it's a punishing tax. Any dollar over the exemption amount is taxed at a 40% rate. So why is this all important? Because if you're a married couple, this has a huge effect on which trust structure is right for you. To AB or not to AB? That is the question. So just to take it one step back, revocable living trust, everybody should have these. When you create a living trust, just a primer, you have settlers. This is the people who create the trust, or also known as trustors. You have trustees, the people who manage the trust. You have the trust, and you have beneficiaries. So a living trust, you are almost certainly the settler. You are almost the trustee or trustees, and you are also the beneficiaries as long as you're living. And then after you pass away, your kids are. An AB trust is one of the two, broadly speaking, structures that couples can have. And when I say AB trust, this refers to what happens to the trust after the first spouse passes away. As long as both spouses are living, you can change the structure any way you want. When one spouse passes away, that's where the AB structure really comes into play. So let's say there's a couple with a $6 million estate. When the first spouse passes away, remember about that stepped up cost basis? The entire community property estate gets a stepped up basis. The surviving spouse can sell those assets, pay zero in capital gains taxes. Now here, if you have an AB trust, your assets are split. So $3 million would go into the A trust, the survivor's trust. $3 million would go to the B trust, also known as the exemption trust. Think of it this way: A above ground, B below ground. The A trust is under the full control of the surviving spouse. The surviving spouse can change its terms, change its structure, change beneficiaries, and then they have control of the money. Now, the B trust becomes irrevocable. The surviving spouse can't change its terms. Well, and that's an upside by itself. Some people like to know, hey, if I go first, I want to know that my wishes are locked into place. What if my wife gets remarried or something like that? It also gets permanent estate tax protection. Unless it's a very large estate, we'd have a more complicated structure. But in this case, that full $3 million is permanently taken out of the estate for estate tax purposes. So even if that grows to $10 million in the next few years, it's irrelevant. It's not going to be touched by estate taxes. That's a good thing. Let's say the assets have grown in value. Let's say the wife outlives the husband by 5 or even 10 years. The value of those assets are probably going to grow. When the wife passes away, assuming she's the survivor, the assets in that A trust get another stepped up basis before it goes to the 2 kids. So that's a good thing, right? And there's no estate tax exposure. Now, the assets in the B trust, however, when they go to the kids, they do not get another stepped up basis. Now, what's the alternative structure? Our firm calls it a continuing couples trust. You also just call this a non-AB trust. So here, same situation, $6 million estate. One spouse passes away, full stepped up basis. Now, we really have to administer the estate properly to capture estate tax protections. The trust continues. The surviving spouse has full control of the trust estate. $6 million in the surviving spouse's trust. It's revocable, and this is subject to estate taxes, but if it's under $6 million or so, and if we take the right steps when the first spouse passes away, we shouldn't be able to, even under the new law in 2026, we should still be able to protect $12 million. So we're not worried about estate taxes. But here, the benefit of not splitting is that there's a full step up in cost basis when the second spouse passes away. There's more issues we have to be aware of than just this. But if you have a smaller estate, the EB trust is probably not the right thing unless you have other goals. If you're worried about the irrevocable nature of it, if you want to lock in your wishes, different issues. But from a tax perspective, it might be the wrong structure. And if you did a trust a long time ago, well, you probably have an AB trust. I think a general rule of thumb, and this is just for tax purposes, is that if you're a married couple and your estate is under $5 million, you don't want an AB trust. If your estate grows or as laws change, we might go back to recommending an AB trust. Larry and Susan have a $3 million estate, including their home. Susan outlives Larry by 5 years. The estate grows to $5 million after she passes away. Their children face over $300,000 in capital gains tax exposure. Wyatt and Jane, $3 million estate. When they pass away, 0 capital gains tax exposure. Now, what's the difference? Well, Larry and Susan had an AB trust. So when Larry passed away, half the estate was put in this exemption trust. And when Susan, the second spouse, to pass away, the assets that were taken out in that B trust did not get another step up in basis. So their kids were exposed to $300,000 in capital gains taxes. Wyatt and Jane, on the other hand, he said, we don't need the AB trust. Let's simplify it. Full step up in basis when the first spouse passed away and another step up in cost basis when the second spouse goes. All the assets pass for the benefit of their kids with 0 capital gains tax exposure, saving hundreds of thousands of dollars. Larger estates. Ben and Ann have a $10 million estate. It grows to $16 million by the time they pass, or maybe it was $18 million. Their estate faces over $1 million in estate taxes. Jacob and Sarah, they also have a $10 million. Their estate also grows massively by the time that they pass. And Jacob and Sarah, though, have 0 estate tax exposure. Now, why is that? Jacob and Sarah switched to an AB trust, which froze part of their estate from estate tax exposure years before. And when the second spouse passed away, 0 estate tax exposure. You need to understand what trust structure you have. And based on the size of your estate and your goals, if you're married with an AB trust, now should you keep it? I think a general rule of thumb, if your estate is under $5 million, at least from a tax perspective, you don't need an AB trust. If your estate's over about $8 million, you almost certainly should have an AB trust in place. Now, if you're in between, it's a gray area. We would talk about it and go through the trade-offs with you. And there are potentially hundreds of thousands of dollars in capital gains tax savings or millions in estate tax issues. I do want to flag, though, that it's not just about taxes, right? Life is more than taxes. Of course, we understand that. And even if you have a smaller estate, meaning still could be millions of dollars, an AB trust still might be right. Now, why is that? Well, what if you're in a second marriage? What if you have children from a prior marriage? What if you're just worried that, hey, if I'm older than my spouse, if I go first, I don't want my spouse to remarry and leave everything to this new family. I at least want to lock up part of the estate for my kids. So that's a case where, regardless of tax issues, you still might want an AB trust. Many families, I'd say, of the families we meet with, I'd say who have smaller estates, I'd say 60 to 70% who had AB trusts from before end up switching, but not all. If you are still around and if your spouse passed away years ago and you had an AB trust and your estate was split years ago, and maybe your house was put in the B trust and it's gone way up in value. If you and all of your heirs agree, we can actually undo an A-B split that was done years ago. We can actually undo it. We can go to court and fix that. If you're confused or overwhelmed by all of this, and it's a lot, I get that. We encourage you to meet with us. You can contact us at 650-493-8070 or gilfix.com. I hope you got a lot out of this, and I hope everybody's staying safe, sane, and healthy. I hope everybody takes care. See you later.